The Alternative Digitalk. Real issues, real talk.
Hi, welcome to the Political Dice.
It's
controversial,
purely political,
well researched,
accurate and global.
Oyagala bya parliament oba council.
Yes, oba ghetto.
Ani ayuga ku ground.
Ani gwe babuze.
Okimanyi nga Dr. Kiza Besigye aleesa amaanyi.
Olwofadda bafutoli abateeseemu obuvaazi.
Oba yo DP eri kuki?
Olwojema.
Bano ba MKCG bo baddawa.
Abo bafuna CDF baamala tebabanja. Olwo baba ate bange bali kuki?
Abo bo akina kulabisa simanyanga posturing tebabiri bali mu structure building. Naye ate ono ye.
Ani oyo oba?
Yali kuki?
Oyo tumuleketa gambanyiga mawu.
Ebe na birindira no kuda Political Dice ku the Alternative Digitalk nange teditenja ewamune.
Karida bikobere
Buli wa Sunday sawa 2.
At first, we hit your gadgets with our state-of-the-art digitalized mobile studio with the debate on the road behind the wheels. Later, we launched our magnificent studios located on Plot 1A, Sawagude Close, Lukulinanganda, Machindye, Kampala, where we bring to you our must-watch shows like The Mighty Drive, Monday to Friday, 8 a.m., Hotline, Mondays, 7 p.m. As for legal matters, Twins at Bar, Tuesdays, 11 a.m., Wednesdays, 6 p.m. is Afro-Caribbean Link, where we connect Africa with the Caribbean. Voltage on Thursdays, 7 p.m., featuring a youthful panel. Interface with Dr. Kiza Besigye every Friday, 12 p.m. with his call to action against injustices. Snap Talk, Saturdays, 6 p.m. with the trio. A must-watch, The Political Dice, Sundays, 8 p.m. with the duo that never stammers, and so much more. Watch us live on all our social media platforms. We are The Alternative Digitalk. Real issues, real talk.
Cap 8, the definition of documents and admissibility. Because the Evidence Act was enacted way back before the ICT era, is the reason as to why Section 8 of the Electronic Transactions Act came in to cure that gap. The same applies to Section 32 of the Computer Misuse Act. They came in to cure the gap that was left by the ancient laws.
They came in
to cure the gaps which were created by the laws that were enacted before the modern ICT era. Your Worship, I just want to give you a small, the reason as to why I'm advancing my argument, and I pray that court agrees with prosecution.
This is...
Yes.
Counsel, this is now the...
Yes, I am advancing my point and I'm going to reach somewhere. Your Worship, why is it relevant to bring the ancient law and then the new law, and how we have to deal with the new law? Our law originated, if you are aware, Your Worship, that it originated from the reception clause.
Before you go there, you didn't tell me about the applicability of these laws, the United Kingdom laws.
It is where I'm coming.
You are coming?
Yes.
Let me
where I'm coming. Our law is best. Much of our law is
originated from the reception clause.
Reception clause. All the order in council, where we inherited old laws including Indian laws, which were enacted in the 17th
We are originated,
century.
where we inherited.
Yes. And therefore,
Old laws.
old laws. And therefore, the growth of the legal framework is developing with the time. It is for that reason that I submit that court considers the ex-handle which is reflected in the charge sheet as a document under the authorities I have cited, which define it. If court is struggling with the prosecution that it is indeed a document, then
If court is
struggling with the prosecution that whatever is in a Twitter handle,
just a minute, it's a document. That's whatever.
then
Just a minute.
then rule N of section 88 applies. And if it applies, then we don't have to go into the details of the contents of the X handle.
If
we simply have to refer to it as X
If it
handle.
applies,
Yes.
then
We don't have to go into details. We don't have to go into details of the X handle as it is. We simply have to refer to it as it is provided for under rule N of section 88. Your Worship, allow me submit that the charge sheet which is before you complies or provides complete information to the accused person.
complies with
Complete information to the accused person. Two, it is legally compliant with the legal standards. That is section 85 and 88 of the MCA. Three, it is specific. The charges are very clear. Four, it has clarity and coherency in that court, the accused, and defense understand the allegation therein. And therefore, the charge sheet is legally sound with no material defects.
sound.
Yeah, with no material defects to prejudice the rights of the accused person,
To prejudice
the rights of the accused person, or hinder a fair trial.
So you are saying that when Mr. Burora looks at this charge sheet, he
Understands it.
understands the charge is against him, and he can able to prepare his defense. That's a
Absolutely.
submission.
Absolutely.
There's no need for amendment.
There's no need for amendment. Your Worship, I'm still submitting. You know, they had a very long submission.
Of Mr. Kamkaba, you sent me, you sent these court documents at 4 p.m. yesterday. I don't know whether you served them. This document came in yesterday at 4 p.m. Did you serve the defense? You served. You open go to seek for another adjournment to peruse.
We don't know it. You're surprised.
I wrote this is the stamp of the registry.
State Chairs, can you contact your staff down there to have these documents with you now? We don't want those games.
Your Worship.
Let's sort this out because it gets back to the accused person's rights. If the documents were served and they're still down there, DPP is down on the ground floor. Pick them up and you bring them.
And my vote for the record was at 2:30, not at 4 p.m.
When they reached my desk, it was 4
I
p.m.
served personally.
And you brought it personally at that time. That's why I indicated the time. As they bring those documents, we proceed.
Yes. Most obliged. Your Worship, giving details of the actuals which the accused person,
The actual words?
yeah, which the accused person used in that publication or document would be more or less,
More or less.
yes, adducing evidence in the charge sheet. Just like
How many Twitter, what do you call those things? Because I'm not on Twitter. So, you call them tweets?
it's
So, how many tweets are you referring to between March and June?
Your Worship,
Which can't fit here?
this is what we cannot go into because it will be evidence. And this is we'll be going into evidence, Your Worship.
Okay, proceed,
because-
Chief Secretary, proceed.
Because issues to do with because the more you try to summarize, is the more you distort the content.
So the more you summarize.
the more you want to summarize, is the more you distort the content,
The more summarize the tweets.
the tricks. Is the more you destroy the content, which might be prejudicial. Your Worship, since we allow me refer you to the charge sheet, much as you read it. As I submitted,
I will not try to because I've read. Submit.
yes. We gave his particulars.
Just,
We give that-
now let me write that. Now
Yes.
that you are showing that. In the charge sheet,
Yes, we gave his particulars.
that use
That
particulars.
is particulars. The period within which the offense was committed, the means,
Let's examine at These are now 10 pages so far on your submissions, you people, huh?
yes.
The
The
means?
Twitter handle, the Twitter handle, I mean the X handle account which was used, the effect, and the victim. Now, what is contention is the content which is supposed to come by way of evidence. That if you
Which must?
which comes in form of evidence, that would be irrational to disclose in the charge sheet.
So you're saying that it will be irrational to disclose evidence in the charge sheet?
Exactly. The information provided is sufficient. Because even then,
so
the rules
information in the charge sheet
is sufficient. Because even then, Section 88 does not specify the details which are supposed to be in the charge sheet. And besides this being a Computer Use Act, which is a new area.
Council video, can you repeat in yourself?
No. I am coming there. Just hold on.
Reach there now.
Yes. I'll refer you. This being a new area, I'll refer you to the case of Parker versus Parker. Parker versus Parker, Supreme Court.
Give us the spellings because we may misspell Parker.
P-A-R-K-E-R. P-A-R-K-E-R. Versus Parker.
Again, same name.
Yes.
Supreme what?
I'll provide, it is SC.
Supreme Court?
Yeah.
Of where?
28, I'm going to provide the details.
Of the Supreme Court of which country?
No, here it is, that's how it is cited. That's how it is cited.
Supreme Court?
Yes, Supreme Court. 28, 1956.
Supreme Court 28?
28, in brackets, 1956. I'm going to provide you with that authority. It is, I just want to quote this, Your Worship, just to emphasize my point. That
I quote?
Yes.
It is stated?
It is stated. That if we never do anything, which has never been done before, we shall not get anywhere. The law will stand still, whilst the rest of the world goes on, and that would be bad for both. That quotation marked the new era of computer and electronic.
That quotation?
Yes, it marked a new era of the admission of electronic documents. My submission in this regard is that yes, is that we shouldn't sleep in the old rules of framing charge sheets. We shouldn't sleep in the old rules of framing charge sheets, which do not apply to computer-related offenses. Because the procedures are completely different.
Related what?
Computer-related offenses.
The procedures?
The procedures are completely different. And the more we stick on to those, and this respect to provide the details of the computer.
The more we stick to all the procedures?
All the procedures. For example, providing details in a computer of the content of that, the more we are bound to prejudice the trial. Your Worship, in this regard, I pray that court finds that
no, you are concluding.
About yes, because they had a lot. They spoke a lot, Your Worship. You have
spoken more.
Yes,
I'm counting the pages.
I want 5 minutes only.
Mr. Kamukama gave me 1.5 pages. No, not 1.5. It was much more than that.
Most obliged. I'm finishing.
But you should be concluding.
Your Worship, the defense provided gave you an authority of Kalungi. Kalungi.
Herbert.
What is the first?
I have
of Kalungi Robert versus Uganda.
By Sydney.
Yeah. This authority has no bearing to the facts.
This authority has what?
Has no bearing to the facts in the case before you. In that case, Your Worship.
Mr. Can you sit? Give him a chair. No, please, Mr. Burora can sit, if you so wish. These people are not soon ending. The out of English as you can see, so has no bearing to the facts of the facts on this complaint has no bearing to the facts of the case in the case
before you. And in fact, the ground in respect to framing of charges were dismissed. The argument that a charge sheet was defective.
Just a minute.
Was dismissed.
So the argument,
yes,
the charge sheet
was defective, was dismissed. Secondly,
let me first see if that is the position.
I'll refer to page 6. Page 6 of the judgment.
That's by Justice Gidudu.
And besides, this was not about particulars of offense.
So the gist
was
was
not
not
about particulars of offense. It was on substantiality of the counts, which is completely irrelevant. I even wondered why it was cited.
It was on substantiality
of the counts. Maybe it was in error, but it doesn't completely apply to us in this respect, Your Worship. Your Worship, I have been informed from court that defense also supplied other authorities.
And he served you.
Allow me submit, Your Worship.
Proceed.
In his submission in chief, he never at any point cited those authorities.
You mean rejoinder is wait.
Yeah, I'm submitting, Your Worship.
Proceed, Counsel.
Yes. He never alluded to them in his submissions. Could I say they were an afterthought? In which event it constitutes litigation by ambush. Just like the papers reach your desk at 4 p.m. Good enough by counsel himself. That explains why we have not received it. But even then, even if we had received them by 4 p.m., that time we are proceeding in court and we are unable to pay attention to them. And therefore, it would be hard for us to come and submit on them. So we pray that court disregards any of such authorities cited by defense.
Even when they resolve the matter in dispute before this court?
Your Worship, the principle of fair hearing applies at all levels.
Court can make research on its own and you can treat it as court research.
Most of most obliged, Your Worship, but for recording purposes, we pray that they are not considered for
conclude.
And as such, we pray that you find it that the charge sheet before you is proper in law and does not offend any laws as submitted by defense. But even if the worst comes to the worst, the same is defective. It is not incurably defective.
It is curable.
It is curable.
By what?
So, Your Worship, we so pray.
Yes, Mr. Katan, are you taking the lead or Mr. Kamkama gets back to the... You are taking? Oh. Who is going to submit? Are you going to submit? It's okay, there's no problem, but... Mr. Kamkama, I'm not putting on record because by the time we started off, we were found when he had started talking. Mr. Kamkama, David. And this is the defense. Have you been given by other council? The last time we were here, we had Mr. Kamkama David, Mr. Benjamin Katana, Philip Munavi, Omara Samuel, Tumusime Kato, Said Kira Arila, and I think that was all. Yes, Mr. Kamkama?
Yes, Worship. For the purposes, we are going to make brief submissions, the three of us. I will make some brief submission of about 2 minutes.
2 minutes when you have the microphone. It's okay.
We will make also some...
Mr. Munavi.
And then I'll conclude.
So we start with the Mr. Munavi. Sometimes you're saying that, I'm putting on record, you're saying that Mr. Katana...
We'll make some brief submission.
Followed by Mr. Munavi.
Mr. Munavi will supplement and I'll make conclusion.
And you will conclude.
Yes. But we will need to accelerate the substance, not veer off the road.
So let's have Mr. Katana first. Mr. Katana, they gave you 2 minutes. I don't know that it will be enough.
Your Worship, I may take less than.
Okay, it's okay.
Your Worship,
Let's go on record.
Brief rejoinder. I'd like to clarify that our contention is not on the absence of full texts, but that the particulars on both counts do not in any way make reference to the particular tweets that are responsible for the accused person's presence as an accused person.
That are responsible for the accused persons?
For his current state of being an accused person.
Just a minute.
Your Worship, Section 88 of the MCA.
Top 19.
Yes, Your Worship. Particularly O. With permission of what I will read it, Your Worship.
I write it? Okay, it's okay. Let me write it. Let me put it. Yes.
That subject to any other
provides subject to
any other provisions of this section, it shall be sufficient to be describe any place.
Shall be sufficient.
Describe any place, time, thing, matter, act, or omission to which it is necessary to refer in any charge.
Which?
It is necessary to refer in any charge in ordinary language in such a manner as to indicate with reasonable clearness.
Even what?
With reasonable clearness. The place, time, thing, matter, act, or omission referred to. Your Worship, our contention is that the charge sheet does not make reference to a particular tweet, a particular act, a particular thing.
Tweet, act, thing.
Yes. For which the accused person is charged for this honorable court. And Your Worship, the essence of particulars, the charge sheet, is to enable the accused person
Before my brother proceeds.
Cancel it. Let him
No, just a minute. With the leave of court.
No, let him first. Let him first conclude, then you can chip in. No? Is to enable the accused person
understand clearly the actions for which he is required to take leave. And it's our submission that the church before this court
is it already defective?
is effective because it falls short of satisfying that requirement.
It falls short of
Satisfying that requirement.
Counsel, what do you want to say?
Just that those are new matters. Those are new matters. What was talked about were the words. There was nothing to do with the tweets. There was nothing to do with the act. I would have brought in also, would have dissected the section in which the accused person was charged, which requires sharing, reading or something like that.
You cited section 85 and that's where council partner is actually getting submitted from 88, sorry. Is actually looking at 880, which you introduced. For him they stopped at 85, you brought 88. So we are in order. Mr. Kanavi? Kanavi, right? No, I've been writing Kanavi. Just a minute, let me collect it everywhere first. Yes, Mr. Mnavi?
So, Worship, in the era of prosecution of electronic related cases.
Electronic
related cases. The submission of my brother here has largely been
of the state.
has largely been on what constitutes a document, to wit, an electronic document. Your Worship, under section 8,
Okay.
That's CMA, Computer Misuse Act. Is it Electronic Transactions Act?
Which one?
Electronic Transactions Act.
I cancel computer misuse?
Yes.
Electronic?
Yeah. Which he cited. Provides that the document includes an electronic transaction. In relation to this charge sheet, specifically, Your Worship, Macha's state may want to beat around the bush, if I can use the right language. It is critical that a source code.
Source code.
Source code. A source code is defined as.
Is this first get it complete and then we go to the definition?
That a source code is provided from which that document or information was sourced.
What's your authority comes from now?
Your Worship,
You know, you have said this thing is new.
yes.
So-
So various readings. I have an article. I have an article for you.
Peer reviewed?
Various readings.
Peer reviewed?
But
Peer reviewed article?
it's not peer reviewed. But
Then it has challenges. If it was a journal that is international, we would accept those IT experts. But this one which I can write and then also tweet.
I'll retract that. But Your Worship, I wish to relate the source code.
It's okay, proceed.
The accused.
Proceed.
Your Worship, the use of acronyms, initials, like at-hada B,
Capital B?
at-hada B, I don't know what at-hada B, which is in the charge sheet, can relate to any person and not the accused. However,
So there can be another H had a B,
yes, Your Worship.
and not necessarily the accused person before
Yes,
court.
Your Worship.
It can even be hacked. That's what you're saying.
Exactly, Your Worship.
Proceed.
Therefore, you have actually concluded my point. It's just obnoxious that we are in court on the charge sheet that does not link the accused to the tweet, neither the complainant to the tweet.
Is this a verified tweet? I don't know. I'm not on Twitter.
Your Worship, we don't know.
We don't know.
It's his source, we don't know. We don't know.
The accused,
It does not link
when the court on every tweet does not link the accused person to the tweets complained of.
neither the complainant nor the person complained of, who is Anita Abong. Therefore, such a charge sheet would stand effective. Your Worship, to back that point, I wish to cite the case of Dawkins versus State.
The case is spell it for me.
Dawkins, D-A-W-K-I-N-S.
In D-O, D?
D-A-W-K-I-N-S.
K-I-N-S.
Versus State. 313
313.
MD 1988.
But which court said? It was stated that?
It was cited with approval in Geoffrey Kazinda.
It was cited?
With approval in Geoffrey Kazinda versus Uganda.
Just a minute. Which case of Kazinda? There are many.
Criminal appeal number 083.
Appeal number?
083 of 2013. Your Worship, the learned justices in Dawkins say an individual would not be deemed to exercise dominion.
Just a minute. An individual
would not be deemed
wouldn't
be deemed to exercise dominion and control on an object he is unaware of. Your Worship,
in this case, in the matter before court,
the charge sheet produced says it does not provide
the charge sheet
produced as it does not provide any link to the accused should be deemed defective and struck out.
It must be deemed
defective.
Incurably.
Incurably, it's defective.
Or it can be curable.
It can't be curable.
And struck out.
Struck out. Your Worship, I'll stop here to allow you to make a ruling at 2:30. No, 12:30.
Your Worship, are they in charge of this court? Is the defense in charge of this court?
That's what the PM
Mr. Kamukama is here from the last man standing. Mr. Kamukama.
Please, Your Worship. I will start by informing this court, Your Worship, that law is a living instrument.
No.
It's a living instrument.
It's not dead.
At no point has it become ancient law, as long as it's still applicable law.
It is still applicable.
Your Worship, if every man of the law, Your Worship, if every man of the law, deem the law ancient, and if every man of the law, deem the law ancient and repugnant or inapplicable, such a law would be amended or repealed, Your Worship. Your Worship, the enactment of the Computer Misuse Act as well as the Electronic Transactions Act.
Just a minute. Proceed.
Did not create new rules of framing the charge sheet. Under section 85 of the MCA, Cap 19. Had it been so,
So you're saying that did not create a new rules of framing charge sheet under that law. It's a continuation under that section, right?
and
There's a full stop of that sheet.
which have been following under section 85 of Cap 19. Your Worship, the main gist of Article 28 of the Constitution of the Republic of Uganda in under presumption of innocence, principle of legality, and presumption of innocence.
I think we started with that one. We started with that one.
Okay. Presumption of innocence, principle of legality.
Is there another principle?
Yeah. No, with that,
And. We put and.
No. My Lord, I aim at buttressing
And do what?
I aim at buttressing liberty. Buttress liberty, which rules high in our constitutional matrix. Which rules high in our constitutional matrix. be given an accused person. Your worship. There should be a clear offense committed. Explain to him to understand it. That's an offense. If you find the fact they are true, you can what? If you was to find the facts alleged to be true, introducibility, and the facts are in doubt, he denies. Worship my young brother for the state. I read that in the month of March, March to June, I got ordinarily each tweet was offensive. Would ordinarily constitute a charge on its own.
You don't bundle them together.
Words are specific. Words are supposed to be specific. They are not roving elements. Worship my own brother for the state, saying that since the accused person pleaded the charge, it meant he understood the charge against him. Worship, anything confusing to the accused person. Anything that is unclear to the accused person. We would never make an accused person say, I don't know, it's not true. Your Worship, again, looking at the language of section 88, you see which my brother introduced this court. The enacting words of that section.
The what?
The enacting words of that section are quoted in mandatory terms.
You that's me that section too. That's me that section. Is it the using shall?
Yes. Worship starts. Every charge shall.
The following provision shall apply to all charges.
Yes.
And notwithstanding any rule of law or practice or charge shall subject this action not be opened to subjection from the content. Okay.
So your worship.
They use the word shall.
It uses the word shall.
So we must comply without exception.
We must comply without exception, your worship. Your worship, we submit that nothing can breathe life to this defective charge sheet.
Nothing
can breathe life to this defective charge sheet. And the number available to this state.
Strike it out.
Strike out and discharge the accused.
The only available remedy.
And discharge the accused person unconditionally. The worship will address the accused rights subsequently. Not in this application.
We are done?
As I close,
you don't become.
No, I'm closing.
He has been closing for the last 20 minutes.
Your worship, this court is a court of justice.
I'm alive to that for prosecution matter. So,
Your worship, Court, we request the court.
When you see Mr. Kamukama smiling, it's just something he doesn't believe in.
That's not true. What in the future should not be overridden by overzealous state. By ramping up presumed charges that are only omnibus and that don't exist to just harass people and impede on their rights. I would have gone to the academia, but
That's
rather important. Then we proceed.
Council, can you get me that case of Brinkins and the state? You can print it out today. Council, the state.
Yes, Your Worship.
Can you get me your case also?
Yes, I'm going to get it.
I have a challenge.
But Your Worship, before anything.
You said you have no right of reply. Sit.
No, in the name of court.
Leave denied. Leave denied.
For purposes of committee, I'm going to supply the authority within a few minutes to allow you
The challenge I'm having is that
But we never talked about the source code. We never talked about the source code. It is something that I wanted to leave of court.
what?
We never talked about the source code, which my brother and
You forgot because that matter was raised.
he should have kept quiet.
The matter
And
was
I
raised.
didn't have to come up in rejoinder, and as such we have to address court about it.
No. I don't agree with you, counsel, because that matter of the code was actually raised by Mr. Kamukama last time. I think it was Mr. Mnawi. So you hope to have addressed it.
Yes, but there was no need for emphasis if we never talked about it in reply.
There is no ambush. There is no ambush. Leave denied. Now, Mr. Counsel, I've given you many cases. Counsel, you gave me many cases. 3 is Justice Kalunji, Kaketo, and Sande. Right? You confirm that you gave me those cases? I'm confirming. I have Kalunji, I have Sande Umaru. Sande Umaru. I also have Kaketo Farouk. So we have 3 decisions. Council Monabi, I want to understand the 2 decisions, the original decision and the Kazinda. So those are 2. State, I want you. So many things. What you call obsolete law. Anyway, what do we do? I'm having so many cases, files. You have taken almost half the time. 11:30. How many files do I have to go? We need to, you have all submitted lengthily. How many pages? There are 15. 15 pages of submission of both parties, and these decisions, I'm going to get these ones. I may not be able to write this ruling now, in fairness, because it has a bearing to strike off and discharge. You do strike off, we move forward. I need some time to really, you agree with me, Council Kamukama, that I cannot write this ruling now. In fairness, I can't. But I'm not going to push it next week. That will be also unfair. So I want to get, I have a very congested diary. Tomorrow is, you can imagine my Wednesday tomorrow is too busy. My 11, it's more likely. So today is Tuesday, right? So if I gave you a Wednesday following, will it be very far? Friday? No, Wednesday is not possible. It is, look at it. No, the challenge, if this is my Thursday, that means being in the court the whole day. So I cannot be, so I want to use this Thursday, which is relatively busier, try the ruling, and then I deliver it on Friday. Because it's my diary, look at it. This is my entire tomorrow. And then maybe here, and then I evaluate on Friday. I think it is, it's all I can do. Because I have to read all these things, and I don't want to take work home. I don't take work home. So allow me use Thursday to try to do, because tomorrow is the day of full, as you have seen the diagram in court, the whole day. So can we agree that we come back Friday at what time? The bus comes at 10, so we can have it to be on 10, at 10 a.m. Is it okay? Just understand, please, Mr. Burora, you have seen my diary. There's nothing much I can do. And actually, they are here to give me these things. So let's agree that we adjourn to Friday. What time? Now I'm going to write after we have agreed. Is it okay or we want Monday?
It's okay. Friday at 9:30.
I will do, the bus dictates.
10.
The bus dictates the time we start. Once we see this posted here, that means they are now ready. Both parties have made legal submissions and some are yet to submit. This court authority cited in the circumstances. This court cannot be trial Friday ruling today. I adjourn the case 12th of July 2024 at 9 o'clock for ruling on the gate of the charge sheet. This person shall be kept on remand until then.
That the charge sheet, the way it stands, it offends the rules of drafting a charge sheet. A person who is appearing in court should be given facts to make him understand the offense actually committed. But the charge sheet that is before court, it alleges that he made words between March and June. The words are not produced. Surely words must be specific. They cannot be guessed. The accused was not told whatever word he made against Anita Monk. He could have made tweets about greetings. Could have made tweets about praising her. But saying that whatever he made between March and June could constitute an offense, we find to be improper and offending the rules of framing charge sheet. And they have not also proved that Twitter handle, which I think that had to be belongs to Anderson, our client herein. Any person can use it, including actually the complainant, can use that Twitter handle and allege that it is our client who is in custody. So we are aggrieved with that. We challenged it in court. They replied. We have further given court clarity and we are waiting ruling on Friday. We so much believe that this empty charge sheet will be thrown out.
The Fourth Estate should also understand that this matter has not been taken lightly. The president of the Uganda Law Society was here today. He joined to see that courts are not used as vehicles of injustice. Like my colleague has said, it's a defective charge sheet, as we are arguing. We have proven that, and as we are waiting for the charge sheet, we send a signal out there that anyone who wants to have a political score should not use courts of law as a vehicle to do that. Olwaleero guno omusango mulabye nti no President wa Uganda Law Society Bernard Owunda agubaddemu ne balooya abalala bangi nnyo beeyongeddeko tubadde nga 17 naye nga message gye tusindika wabweru eyo nti courts zireme kozesebwanga kkubo ery'okuvugiramu abantu mu nfuga oba mu nkola etali ya mazima na bwenkanya. Nga muganda wange bwayogedde charge sheet gye baleeta esobola okukolebwa omuntu yenna
nga mulimu n'oyo acomplaining okuba nti yagikola. So okubeera nti omuntu abadde mu kkomera kikotte ku buli omu, civil society ebaddewo, Uganda Law Society ebaddewo, okulaba nti n'amazima n'obwenkanya gakolebwa eri oyo eyavunaanibwa.
Amanya Zeka Mukama David, leading timu ya Herbert Anderson. Okumugunya kwaffe kugamba nti byebanvunaana mu kkooti ebiri tetunabiraba nakati. Bamuleta mu kkooti nga bagamba yatyoboola erinnya lya Speaker wa Parliament, naye teri bigambo byonna bye baleese. Bagamba teyogere bigambo kuva mu Gwokusatu omwezi kutuuka mu Gwomukaaga. Naye tekigambo na kimu kye batadde mu kkooti okulaga nti yakyogera ate kityoboola erinnya lya Speaker wa Parliament. Politicians tubasaba bwe mwagala kulwana entalo temukolesa kkooti. Ate politics za kwogera n'okwogerwako. Wetagala kwogerwako tugenda mu politics. Naye kitumanyi nti singa bali balina ebituufu lwetwava wano ku Lwokusatu singa bali balina ebituufu ebyo bagamba nti client waffe yabyogera bandize n'amended charge sheet ne bagireeta leero mu kkooti. Engeri batagireese leero kitegeeza nti byonna ebintu byalina byabyanswa beesibako omuntu basitoringa political scores. Naye tumanyi nti justice at the end of the day ejja kulabika ate ejja kukolebwa. Kiba kintu kifu ogenda mu kkooti n'otandika kwewozaako ku musango gutaliiwo. Tusaba kkooti emute adde waka ebinaaddamu tujja kulaba bwe tubikolako, naye kati twagala tusooke tugende ku rights z'omuntu waffe bamufulumye ave mu komera.
Bapita Katutu Musime ndi omu ku bannamateeka abawolereza omwami Burora Anderson gwe mulabye mu kkooti ya leero. Kuva olunaku olwasooka okujja wano mu kkooti, ensonga yaffe gye twasookerako yali yakuchallenginga kye tuyita charge sheet oba olupapula state law yakozesa okuwabira n'okuloopa omuntu waffe oba client waffe Burora Anderson. Ensonga ze tujjayo mu charge sheet eyo ziri nti state mwe yali ekola charge sheet yayo teyagoberera amateeka section 85 and section 88 za Magistrate Court Act nga amateeka agagoberera ki charge sheet bwe yandifaananye na biki byanditaddemu kye twasooka okuchallenginga mu omulundi ogwasooka okujja mu kkooti. State neesaba obudde okuddamu mu preliminary objection oba okuwakanya empaaba ya state gye twakola mulundi oguli ogwasooka, era kyekoze leero naffe ne tuddamu, era ng'ensonga yaffe neero ekyali emu. Tugamba nti bye balina okuteeka mu charge sheet nti basobozesa omuntu waffe okutegeera nsonga ki lwaki ali mu kkooti ng'omuwaabirwa tebabiteekamu, era olw'okuba nti charge sheet bw'ebeera in that defective manner kkooti terina buyinza bugendera kweyo ate n'ekyajinga omuntu waffe n'emusindika eruzira. Effect yabyo eri etya nti kkooti bw'egenda mu maaso n'egoberera submission zaffe ze tutaddeyo ze twateekayo ne ze twongeddeyo leero na authorities ze tutaddeyo leero nti erina ekintu kimu kugoba eyo charge sheet oba ne bagijja ku record era omuntu waffe ne bamuyimbula nga tebalina kyebekwasiza kyonna. Yensonga lwaki tetugenze mu maaso na kusaba bail, kubanga tetusobola kusaba bail ku charge sheet gye tulowooza nti eri defective era evoola amateeka gaffe kyegogera ku charge sheet bwe yandibadde efaanana. Yensonga lwaki tubadde mu kkooti era ndowooza mulabye arguments zibadde z'amaanyi, naye neera ffe kye tukyaliko kiri kimu, kuba amateeka ge tusaitinze oba ge tubuulidde kkooti galaga biki state bye yanditadde mu charge sheet, era omulamuzi bw'ababuzizo oba balina essuubi erikyusa charge sheet egoberera amateeka kye bagamba ne bagamba bo tebalina. So ensonga lwaki tulinze ruling era tusuubira ejja kuba ku side yaffe, era omuntu waffe tusuubira by Friday bajja muyimbula nga tebalina kyebekwasiza ali ebutaala. Tulinde state bwe naabe emaze okwetereeza enaddamu emucharginga ebirala.
Anderson Burora yali munnaffe era munnaffe. Anderson Burora yakola ekyobuzira abavubuka abamufaanana bwe yaleka obulamu bwe babeeramu najja eno gye tuli ne tufuuka abannayuganda aboogera ku nsonga ezinyigiriza abantu ng'obuli bw'enguzi, nga okweyambisa obi ofiisi zaffe eza gavumenti, nga okulagajjalira abavubuka. Ze zaali ensonga enkulu mu kisinde kye twalimu ebiseera bye kibayitanga Jobless Brotherhood, NRM PYUC n'ebiringa ebyo. So Anderson conviction zamutwala okutestinga system ng'agiweereza ng'alowooza judge influencinga ne personality ye. Tuli basanyufu nti alemedde ku cause. Tetuli wano ku lwa Anderson kyokka, tuli wano olw'olutalo lwe twatandika olw'okuvumirira obuli bw'enguzi naddala ku Parliament. Anderson bw'abanga kati akalabuka n'Anita Amongo wekkiriza abagana Abibu Buwemba ali wano, tumiyimbise Norman ali wano, Richard Kirekyankuba ali wano. Mu bumpimpi waliwo Jobless Brotherhood, waliwo Alternative, waliwo NRM Poor Youth. It's like a repetition of the past.
Nze Norman tumuhimbise National Coordinator wa Alternative Social Movement. Kubya Anderson ebyamukwasiza ne bweyandibadde Janet nga yabyogedde twandibadde wano. Janet olunaku lwavaayo naye n'abyogerako munno banne babba twandibadde wano. Naye okwongera okulambula ensonga zino nti okwongera ku ddoboozi ku bannayuganda abavuddeyo ne babaako bye boogerako naddala nnyo of Anderson byayogeddeko n'abalala abalina ebyamaanyi bye boogedde nga for that matter tetuyinza kubalekerera naddala nnyo nga batunuzaamu emmundu embi nabwe kityo tetuyinza kulekerera Anderson so as long as byayogerako biruma munnayuganda naddala nnyo okulabula naddala nnyo bannayuganda abalonda bannampawengwa naye nga bannange nga bagambye nti twebaza abakutte Anderson nti bazuukusizza abalwanyi abakadde nabwe kityo tebeevumanga nga ffenna tukomyewo nga bannange bagambye tugenda komawo tulwanyise abantu be balonda nga bo bambi balonda tubayita bandabakuki bano bwe bafuna ebifo bino ne beefuula abanene so nabwe kityo tuyinza kubaleka kutubba ng'ate abalwanyi tukyali balamu era tukubiriza buli mulwanyi yenna waali akomewo emmundu muziwawule ezalwanako Ssematalo eyasooka n'owookubiri tuzikomyewo oba kisasi kimu oba zitya emmundu zonna enkadde tugenda zikomyawo ku street essaawa yonna.
Ekyankuba Richard bye twali twalwanirira edda bye tubadde tujja tulwanyisa bye bintu Bulola byali mu kulwanyisa tetusobola kutuula eyo ne twerabira ne tubiraba bulabi ku TV ne tubiwulira bulizi ku mpewo nga ffe ababimanyi obulungi obikola tulaba bulabi so yensonga eno in fact njagala okutwala omukisa okwebaza abavunaana Bulola batuzuukusizza mwebale nnyo mwebalire ddala action pact kati era nkibwero eriroded tugenda kubagana namwe kira niti nani simanya anita mongi omuntu asobola kubeera n'amaka nga gegandibadde eddwaliro ly'abantu gobere n'eddwaliro ssebo nze eryandibadde eddwaliro lyange gwe ng'osula musule boys kwota ya Anita Mongi boys kwota ya Anita Mongi esinga essomero mwana wange lyasomeramu ku ssente yange alimba boy nedda Anita alimba betwali tulochinga olutalo ne Bulola twasaba ekintu kimu senga Anita atusiba senga Anita atutta Mukama Katonda weebale nti bye twategeka bye bino bye tulimu byennyini Anita betwakusaba byoli mutukolera tujja ate ku mulundi guno tujja
kitulese ku kooti si Anderson Burora naye ye cause gyaliko omanyi bannayuganda balina ekintu kyebadde tebalaba media tubuzabuzizza ate nnyo naye olwaleero ffenna tusituse tukwasaganye ku nsonga y'obuli bw'enguzi bw'okwata omu wisobbulo w'omu oba ogezaako kulaga balala nti musirike buli anaavaayo nja kukola ki nja musirisa naye kyemmanyi kyebadde tebalaba nti already bannayuganda you can fool everyone but not for a lifetime tuvuddeyo olwaleero okulaba nti tuyimira ne Bulola irrespective of the byonna ebyaliwo emabega tubiziza naye tuli ku koozi twagala eno ensonga y'enguzi tubeere nga Museveni alekerawo tumanyira okutuuka ku nsonga tusirise tetuli baana bato tuli basiru okudda gye tuli ne tukola ebyaffe ne bakola ebyabwe ne boonoona buli kimu ne bapamaapama buli kimu tekitegeeza nti tetukyategeera kati ate yagenze n'akwata ono omwana n'amutwala mu ne bannaye Uganda nze sikyalina kye ŋŋamba bannayuganda katulwana olutalo lwaffe lwe tutandise ku luno tukomawo ensonga teri ku Bulola eri ku buli bwanguzi.
At first, we hit your gadgets with our state-of-the-art digitalized mobile studio with the debate on the road behind the wheels. Later, we launched our magnificent studios located on Plot 1A, Sewagude Close, Lukulinanganda, Machinde, Kampala, where we bring to you our must-watch shows like The Mighty Drive, Monday to Friday, 8 a.m., Hotline, Mondays, 7 p.m., As for legal matters, Twins at Bar, Tuesdays, 11 a.m., Wednesdays, 6 p.m. is Afro-Caribbean Link, where we connect Africa with the Caribbean. Voltage on Thursdays, 7 p.m., featuring a youthful panel. Interface with Dr. Kiza Besije every Friday, 12 p.m. with his call to action against injustices. Snap Talk, Saturdays, 6 p.m. with the trio. A must-watch, The Political Dice, Sundays, 8 p.m. with the duo that never stammers, and so much more. Watch us live on all our social media platforms. We are the Alternative Digitalk. Real issues, real talk.
Hi, welcome to the Political Dice.
It's
controversial,
purely political,
well researched,
accurate and global.
Oyagala bya parliament oba council.
Yes, state house oba ghetto.
Ani ayuga ku ground.
Ani kwe babuze.
Okimanyi nga Dr. Kiza Besije alesa amaanyi.
Olwofadda bafutoli abateesemu obuvaazi.
Oba yo DP eri kuki?
Olwojema.
Bano ba MKCG bo baddawa.
Abo bafuna CDF bamala tebabanja. Olwo baba ati bange bali kuki?
Abo bo akina kulabisa simayanga posturing tebabiri mbali mu structure building. Naye ate ono ye.
Ani oyo ba?
Ye ali kuki?
Oyo tumuleketa gamu afanyiga mawu.
Ebe ndabena birindira no ku the Political Dice ku the Alternative Digitalk nange Teddy Tenjo ewamune.
Farida Bikobere
buli wa Sunday
sawa 2.
The Alternative Digitalk. Real issues, real talk.